Good morning, I'm Father X. In this episode, I'll talk about how judges think about 3 specific best interest factors so that you can get inside their head. And once you know how judges think about things incorrectly, then you can create your testimony to show them the correct way to evaluate the facts. The 3 best interest factors we'll discuss now are maintaining stability of prior court orders, existing parenting agreements between the parents, and the primary caretaker. The first 2 have the goal of maintaining stability in a child's parenting schedule. Courts use current agreements, whether they were court-ordered or made by the parents, as a starting point for parenting schedules because consistency is good for a child's well-being. Courts prefer not to make immediate changes. Why? The courts don't want the child to live mostly at mom's house for 4 months, and then with dad for 5 months, and then with mom for 6 months. The goal is to keep things stable until a final plan is decided, unless an urgent situation comes up that requires immediate changes for the child's safety or well-being. Let's go deeper into these 3 topics. First, maintaining the stability of prior court orders. If there's a temporary or final court order in place, the courts prefer to use that as a starting point before making any changes. On your first day in court, the parents might spend just 30 minutes presenting some arguments about why you each should have custody. But that's just an introduction for the court to your case and not a thorough discussion. Please review my episode 6C about your first day in family court to learn how to handle this. On that first day, the court will issue temporary orders to establish a parenting schedule. Almost by definition, these temporary orders are half-baked and uninformed. With temporary orders, if the mother is given primary custody with no fact-finding, no trial, no hearing with testimony or evidence or witnesses, and no analysis of all the best interest factors, then the temporary order is not an official determination of the true best interests of the child. That official determination can only be made after a full trial with analysis of the testimony, evidence, and witnesses. With temporary orders in place, you can request changes to the parenting schedule during the court process based on new information, and the judge may or may not agree to it. Smaller changes like increasing the dad's parenting time from 5 to 7 nights a month are more likely than bigger changes like going from 5 nights a month to 15 or 24 nights a month, where primary custody would change. The likelihood of changes depends on the circumstances. With final custody orders, these are issued after a trial with witnesses, evidence, and testimony. You can try to change final orders by filing an appeal or a motion for reconsideration, depending on your state laws, but that must be done by the deadlines to file those. If you don't appeal by the deadline, then the final order stands. After the deadline to appeal, to change final court orders that have been in place, you have to file a new custody petition. Generally, you have to prove a change in circumstances to show that prior orders were made under conditions that no longer exist. And you need to prove that, given the change of circumstances, it's better for the child to be raised by you primarily or on a 50-50 basis. A judge can modify temporary orders if they feel like it. But after final orders, a change in custody requires a change of circumstances. Be sure to confirm this with your state laws because rules vary by state. The questions you can ask yourself to prepare for this are: has there been a final decision by a court where, after fact-finding, there was a determination of the best interests of the child? What exactly was that determination based on? What change of circumstance has happened? Has the mother's home environment become unsafe for your child? Has the mother been arrested or developed an alcohol or drug problem? Is she physically or psychologically abusing your child? Has the mother prevented you from having your parenting time or alienated the children? Are the kids now teenagers who want to live with you? Or is there another reason? A warning for you: if the judge gives the mother temporary custody, it doesn't legally mean it's in the child's best interests. It only means the judge had to make an instant, temporary decision right now, and this is what they came up with. As the case progresses, the mother, her lawyer, and others will probably pressure you by saying, "The judge gave mom temporary custody, so we know she'll get final custody. You should just settle now and let mom have primary custody." This is a common manipulation tactic. Don't fall for it. A full trial is still required to determine what's truly in your child's best interest. They're hoping you'll get scared and give up, so mom can get custody, uncontested, without a trial where everybody can look at reality. Second, existing informal or written custodial agreements between the parents. Generally, if parents already have a parenting time agreement before going to court, then the judge will likely keep it in place temporarily for stability, unless something drastic has happened. The longer it's been in place, the stronger the case to keep it the same. To change it, you have to provide testimony and evidence about why this arrangement is no longer in your child's best interests. Be specific about how it negatively affects them and how your proposed parenting schedule would be better for your kids. Here's something I learned. A final order on custody after a fact-finding trial is legally assumed to be in the child's best interests because it's assumed all the facts were considered by the judge. We know that's not true because judges often don't get all the facts or consider them, but legally it's assumed the judge did so. A temporary order is not assumed to officially reflect the child's best interests since no fact-finding hearing has occurred yet. A parenting agreement is also not assumed to officially reflect the child's best interests because there's no presumption that the parents reviewed the best interest factors required to be considered. However, even though a parenting agreement is not absolutely assumed to reflect the best interests, it's given significant consideration by the courts because courts prefer to let the parents decide together. Key questions you can ask in your testimony are there any verbal or written agreements between the parents for parenting time? What parenting time does each parent have? Was the agreement intended to be temporary, pending a long-term solution? Can you prove with emails or verbal statements that it was intended to be temporary or permanent? How long has that agreement been in place? Have both sides consistently abided by that agreement? Has that parenting arrangement been in place long enough that it should be considered the status quo for your child going forward? How would your child's life change exactly if we changed that parenting arrangement? What are the positive and negative impacts? Some impacts can be a new or better school, a new neighborhood, new friends, moving closer to relatives, freedom from the other parent's abuse or child endangerment, a higher income household, ending the need for a babysitter, a more stable home, stopping one parent's parental alienation, or other reasons. You should take any informal or formal agreements between you and the mother very seriously because they can come back to haunt you. How? If you and the mom break up and you leave the home and you agreed to deal with custody later, but for now your child will just stay with the mom, then you have just granted the mother primary custody. And later in court, it's hard to say the mother is unfit to raise the child. Everybody in court will say that you agreed the mother was a fit and better parent when you left the child with her. So if you later go to court for primary custody, then you have to show what's changed to make the mother unfit, or show that you were wrong in your prior belief that she was fit. If you're breaking up, don't move out until you have a written parenting schedule with the mom. Even if it's just a simple email agreeing to 1 week on and 1 week off for 50-50 custody, for example. Watch my episode number 8 to learn how to make parenting agreements. If you leave the home hoping to resolve custody later, then the court might assume you just abandoned the child to the mother. Obviously, it's not abandonment if you leave the home on a Monday and file for custody on Tuesday. But if you leave and wait several months to file for custody, it can hurt your case because the primary custodial parent is usually the one that will always stay with the child, not the parent that walks away for months. Do you see how important it is to think and act like a true custodial parent? Third, primary caretaker. In a common example, if the mother was a stay-at-home mom and the father worked outside the home 40 hours a week, then judges often rule that the mother should continue being the primary caretaker as the primary custodial parent. However, that's lazy, simpleton thinking, because the question goes far deeper. You can't assume the mother should now be the primary parent just because she spent more time with the child. You can't assume she better meets the child's emotional and other needs, or that she has a stronger bond. While this is true sometimes, a judge shouldn't take it for granted in every case. You need to confirm or deny if these assumptions apply to your situation, because the judge is unlikely to put any real effort into figuring out the truth. I myself had to fight this stereotype because I was a stay-at-home dad for the first 8 months of my son's life while his mom worked. When I went back to work, the mother became a stay-at-home mom for 2 months, and then we went to family court. Family court gave her temporary custody just because she was an unemployed stay-at-home mom as of that day, and she was available to parent. And family court initially ignored the fact that she was violent, abusive, threatening to end her life, and had a significant history of psychiatric illness. I'm showing you what I did to overcome these lazy primary caretaker stereotypes that courts use, and how I got primary custody. Questions you can answer in your testimony are: before court got involved, if you lived apart, which parent did your child primarily live with? If you lived together, who was primarily taking care of your child? Why? Did that change over time? Discuss each parent's role and frequency in caring for your child. Who did what? Break down parenting duties in the morning versus afternoon versus evenings versus weekends. Watch my episode 11B to learn how to testify about who took care of your kids' basic needs. Has the mother cared for the child's needs adequately? Just don't criticize petty things. Is it actually true that the mom and child have a stronger bond because they spent more time together? Even if the mother was the stay-at-home parent, it doesn't mean the father and child's relationship can just be dismissed. Even if the dad worked 40 hours a week, he had daily routines with the kids. Did he make and eat breakfast with the kids? Did he take them to school or pick them up from school? Did he check homework in the evenings, read to them at bedtime, or tuck them in at night? Did dad take the kids to medical or dental appointments? Did the father spend a lot of evening and weekend time with them, such that the father and kids also have a strong bond? This is how you destroy the stereotype that only the stay-at-home parent was the primary caregiver. It's your job to testify in detail how you shared parenting duties, and describe how it would be a shock to your kids' lives if your presence was deleted and you just became a weekend dad for them. Every family is different. In some cases, the father can earn more, so he's the one who works while the mother stays home. But the father might also be the better parent, but he can't do both jobs full-time. If the mother isn't as good a parent as you, then challenge the assumption that the stay-at-home parent should automatically have primary custody. Judges probably won't question this assumption on their own, so you have to assertively make them think about reality. Also, the two parents used to live together and split the responsibilities of working and parenting. But now, each parent needs a job to financially support their home, and they each need to be a single parent. In this new world, she can't be the primary caretaker who's only a stay-at-home mom. Which parent is better able to manage both working and parenting, now that you're in two separate homes? Explain why you're better. Also, if the mother was the primary caretaker, and you think she's a fine mother, then that's okay for you to say. Just don't make her out to be a far better parent than you, because you risk that the court will make you an alternate weekend dad. And you don't want to lie or complain about minor petty things. If she's a fine mother and you want 50-50 custody, then you're more likely to get 50-50 custody if you can both get along, work together, respect each other's parenting, and not insult each other in front of the kids. Finally, if you never lived with your child, that's the subject of this custody case, can you take on the role of 50-50 or primary caretaker? Why? What experience do you have? Did you already raise other children in a separate relationship? Did you care for your own younger brothers or sisters? If you don't have prior experience, that's okay. Nobody's a parent until they are a parent, including the mother. But if you do have prior experience raising kids, show it as a positive. So now we've covered 3 more best interest factors. In the next episodes, we'll discuss more best interest factors so you can learn what to talk about and how to put it together for your judge. These might be the darkest days of your life. They were for me. I'm making these educational videos to help you navigate this nightmare. If you subscribe, you can get updates when I post more videos. Thank you for liking, subscribing, and sharing with your friends who are in a similar situation. Please support this channel so I can make more videos. You can donate via my YouTube channel's About page using PayPal or Venmo.